Hello friends, how are you? Today I will discuss in the present law lecture series the basic strategy to fight with the cyber crimes. Usually in nowadays, the cyber complaints are going to be lodged against the concerned person on the ground that online fraud has been committed. So what will be the strategies, how to contest these cases and how to claim the bail in these type of cases, because it is not necessary that every person who is suspected is actually involved in the crime. So sometime by doing the unfair investigation and by adopting any coercive method including the compulsion method, the innocent person are involved in a serious crime of cybers. In that scenario, the accused is having no strategy. Even the relative of the accused, even the advocate of the accused advise him to go for confession so that he could have a minimum imprisonment. But this is not a way. If you are a human being, you have a right to live with a human dignity. And Article 21 of the Constitution of inter alia supports you. So when the things are in your favor, then why does it need to worry? If you are not a criminal, you are innocent, just remember one thing. Fight for your rights, because as for Darwin, if you want to survive, be ready for war. So today I will discuss the strategy for bail in a cyber crime involved the cyber thuggy, the online fraud. So topic is very much important. Please be on the line. And apart from that, I request all of you to watch this video completely, to have a complete knowledge of the subject and note down the point in a copy or a register maintained by you. So that in the near future, if you are having this problem, your friend is having this problem, or your relative is having this problem, this video is quite beneficial for them and even for you. So let's start the topic. Friends, I am going to discuss the judgment of Honorable Odisha High Court, which is passed in case of Santosh Kumar versus State of Odisha. Judgment date is 17th of February 2023. Now you get the credential of the case. Now friends, I am coming on the case title. The judgment is passed between Santosh Kumar versus State of Odisha. In this case, the matter was heard through hybrid mode, means through VC. The application is filed under section 439 of CRPC. It says that you have a right to get the regular bail in case you are taken in custody in connection with a crime. The crime may be serious, may be general, but crime is crime. In that case, the petitioner has applied for grant of bail in connection with the FIR, which is registered by CID CB Cyber Crimes. That is very important, Cuttack. And the case number is 14/2019, pending in the concerned court for the commission of offences punishable under section 419, 420, 465, 468, 471, 506 and 34 of IPC. But remember one thing, in all this section, maximum punishment is of 7 years. So the accused is entitled for the benefit of section 41A of CRPC. And apart from that, section 66C and 66D of the IT Act is also imposed, but subsequently charge sheet has been filed for the commission of offence under section 419, 420, 465, 468, 471, 34 of the IPC with section 66C, 66D of the IT Act. The allegation against the accused is that he has committed the online fraud, means purchasing one website from godaddy.com and letting it to the co-accused for committing the financial fraud. That is a basic allegation. So the allegation of false personification, allegation of cheating, allegation of forgery, allegation of interfering with the computer system, and apart from that, the cyber personification is on the record with intention to implicate the accused by alleging that he has committed the crime of serious nature. All of you, I think, that got the point. So by this factual score, we could conclude the following two things: that a crime has been committed. Number two, it's a serious crime because a financial fraud has been committed, and the mode is that one of the accused has purchased a website from godaddy.com and inter alia let it to the concerned co-accused for committing the financial frauds. So it is a very serious case, and each and every day we are usually heard regarding the sad cases on the social media and in the local newspapers. Okay, now in course of the bail application hearing, the concerned accused submitted that the accused has been falsely arraigned. In the case, there is no connection of the accused with the alleged crime, even with the alleged financial fraud. Even though the material taken into consideration, the only thing appears is that he is the owner of the website, but there is no monetization has been done, or anything has not been received by the petitioner either in his own account or in the account of any co-accused. So the allegations against the accused persons are totally unfounded, and until and unless the allegations are totally founded and connecting the accused with the crime, he could not be arrested as an accused. So in that case, I do not know what actually happened, but on the papers, the concerned CID CB Cybers has not produced any material to show that in consequential of that website any monetary benefit has been obtained by the accused or by the co-accused, either in their own accounts or in the account of any concerned person. So if the element of conspiracy is not there, if the element linking is not there, so accused could not be said to be a culprit. And apart from that, accused in custody for a long time, so it is a very fit case where bail could be inclined. Apart from that, the same has been opposed by the concerned prosecution, but the court specified that there is no dispute that there is no money transaction, but he submitted that he is required and he is to be kept in the confinement without any reason. Friends, I want to clarify that the life and liberty is the prime concern. If you are not accused, you are kept in the confinement and you are having a right if the investigation is not done within a contemplative period as per section 167 of CRPC, if the trial is not done as per provision of 437 CRPC, and apart from that, long custody without having an efficient material on the record inter alia entitled the accused to get the bail remedy from the concerned court. So in that scenario, the court, by looking to the fact and circumstances, submitted that or specified in the judgment that the concerned accused cannot be placed in custody for the infinite period and definitely he deserves to be admitted on the bail. So the allegation can be decided in the course of trial, but the thing should be there that he has misused his liberty or he may misuse his liberty. The key point should be there. Apart from that, he is threatening or he is going to tamper or he is going to hamper the trial proceeding. If these stands are not on the record, the accused could not be kept in the confinement for the infinite period. So in that case, even though the offense was serious, but there was no material, a clinching material and incriminating material that could connect the accused with the crime. So looking into the fact and circumstances, the accused has been released on bail subject to the furnishing of personal bond and the surety bond. So friends, it is a very easy case to be understood. The key point is that whenever you are going to be implicated, do not lose the hope. Just fight your case and emphasize on the clinching points which are going to connect you. If there is no connecting evidence, the prosecution has brought the case on mere surmises and conjecture, mere hypothetical basis. In that scenario, they could connect you with the crime and you could not be kept in the imprisonment for an infinite time. So it is your legal rights. Now things depend upon you, whether you will enforce or will confess. So friends, see you in the next video. Till then, subscribe my channel. Jai Hind, Jai Bharat.